Here's what to do if you're taken to jail, according to the Redemption Manual 4.5 edition, How to Become a Secured Party Creditor, Understanding the Matrix, and Taking Commercial Control. This page does not have to go into any lengthy detail. Remember, if you are taken to jail via a fresh arrest, try to get the names of the officers involved in your arrest who caused the most injury, threat, or pain. Try to keep the details of your fresh arrest in your head, as most likely they won't give you a paper and pencil. Do not sign in. Do not answer questions. Do not give fingerprints, etc. Only after their threats, and do not sign when you're getting out. As soon as you're out, you need to do up an affidavit of all the facts and the unlawful, of all the facts of the unlawful arrest. It is best that you have someone that has your power of attorney to assist you in these matters until you are out. But when you find yourself in a jail cell, for whatever reason, you've heard the stories, seen it in the movies, that you have the right to one phone call. So the question is, who do you call? Well, it's not to call your lawyer, God forbid, your girlfriend, your pastor, your bondsman, your buddy, or your bookie. The only reason for one phone call is to call the judge. Seek the name of the judge and try to get the phone number from the jailers. Be businesslike and polite, but firm. It is your part of your due process. As they say, you have the right to one phone call. Merely state that you need the number so that you can request an appearance bond without fees or cost. This must be requested preferably before your arraignment. Note, the appearance bond is the bond that the prosecutor puts up to bond the action brought forward by the traffic officer, cop, or he himself. They created the quote-unquote action. They have to bond that action in the event that they injure you in their misapplication of statutes or other injuries that may occur. If you are denied the phone call, then make a request at the next available opportunity, either with any agent that comes to you and or when you are taken into court for arraignment. Remember, you want the appearance bond as part of your due process. And if the judge produces the bond, you can state that you accept the bond for value. I do not intend to challenge the facts of the case. I plead guilty to charges in behalf of the defendant debtor, but that's not me. And I request the court to discharge the charges via the bond, and I request that the bond be released to me. If the judge denies the bond, he then has denied you remedy, due process in parentheses, committed commercial fraud, as the charges are not laid on you, but on the corporate fiction, the defendant debtor. And since you cannot pay the fine or pay off the commercial charge and can only be discharged, and being the insurance policy via the bond is created by the prosecutor or some other agent via the case, is to be brought forward to indemnify the man creditor sovereign in light of the bankruptcy, as everything is insured. But the system most always gets the arrestee, which would be you, to bond the case yourself or get you to plead guilty and or consent to the charges. If the bond is denied at your next available opportunity and or with someone you have given the power of attorney to, if you are still incarcerated, you can exercise your exclusive remedy, and that is a tort claim. A tort claim is a lawsuit filed to claim compensation for the injuries a victim has suffered in an accident. Or common tort claims include assault, battery, damage to personal property, conversion of personal property, and intentional infliction of emotional distress. Injury to people may include emotional harm as well as physical harm. When an individual is detained without warrant and without having committed a crime, such as a traffic infraction, which are not crimes, the detention is a false arrest and an unlawful imprisonment. Plus, if you are coming into the understanding of things, read previous, and to what's going on in the courtroom, which is just a business, the following is presented for your edification. Comment before the judge. I demand an appearance bond or a personal recognizance bond to be issued forthwith. and respectfully demand a waiver of the fees and costs, so I can appear and plead to the charges, during which I will stipulate to all the facts and accept and return for the full settlement and closure in the transaction. The bond indemnifies the action. He's asking for the fees to be waived so that he can plead to the charges in behalf of his debtor defendant, as identified on the charging instrument. But that's not me, and I do not intend to challenge the facts, and then in parentheses it says, because you cannot argue them, and the defendant is guilty. And I'm here for settlement and adjustment of the account, so upon your judgment presentment, I will accept it for value and return it for discharge to settle the matter. The judge may go case dismissed, or he may run out of the courtroom and scream, why? Because now the judge is acting as an unlawful debt collector for an individual debt that the other parties defaulted on already. If the judge rules against you, or debtor, or whatever, to cause commercial injury or misapplication of the statute, your only remedy is a tort claim.